Hello everyone. Today we are going to discuss about two important provisions of the Civil Procedure Code. Of course, we have seen different provisions when the plaintiff appears, and what about the appearance of the parties, the appearance of the plaintiff, appearance of the defendant. Then after that we have examined the other provisions, and we have decided to have a overview of all these provisions once in English once again. Today we will be discussing about interim orders, that is two important orders, that is interim orders, which is interim orders. According to the Civil Procedure Code, there are two provisions, that is order 24 and order 25. So we will be discussing about these provisions today. First of all, what is the meaning of interim orders? What do we mean by interim orders? Interim orders are those orders which are passed by the court in between when the case is filed and is pending before the court and it has not yet been decided. So within that period, if something happens wherein a party needs to file an application before the court for some relief, which relief is necessary so that he does not lose his rights at the end of that suit. He files the suit for a purpose, and if his rights are protected, then only he can get the relief in that suit. So there are a number of interim orders which can be given. Out of that, today we will be discussing two interim orders. One is payment in court, order 24, and security for cause, that is order 25. What is an interim order, or what is an interlocutory order? Interlocutory means which only settles some intervening matter relating to the cause. So whatever the cause of action is there, according to that he has filed a suit, some matter which relates to the cause will be decided only in part. To just explain, orders which are passed by a court during the pendency of the suit means these orders do not determine finally the substantive rights and liabilities of the parties. The substantive rights and liabilities of the parties in respect of the subject matter of the suit or proceeding shall be decided when the evidence comes before the court and when the court decides the matter on merits. Before that, if the relief is required, then the court has a power. It has to have a power to give interim relief. So section 94E of the Civil Procedure Code says that after the suit is instituted by the plaintiff and before it is finally disposed of, the court may make interlocutory orders as and when it may appear to the court to be just and convenient. So the main thing is the court can make interlocutory orders if it is just and if it is convenient, not otherwise. That we should be understanding. Coming to the object of this interim orders, all the interim orders, they are necessary to deal with and protect rights of the parties. This rights has to be protected in the interval between the commencement of the proceedings and the final adjudication. So during that time their rights have to be protected, and that is the object of this interim order. Then the second object is to grant such relief which may be just or equitable. Thirdly, they may also prevent any abuse or process during the pendency of the proceedings. For example, if a person files a case for an injunction, that is a interim injunction. Suppose he files a case for possession of a property on the ground that the defendant has entered into his property, or he has taken wrongful possession of his property, and he files for declaration and possession. So during that time, to take advantage of the time interval, the other party may try to dispose of the property, the other party may try to transfer that property because he is in possession. So then he may try to abuse the process of the court, saying that the court is taking its own time. So the court can give the relief later on. So within that time he may have his intention fulfilled. So for that purpose, to prevent such abuse of process, it is necessary for immediately the court should grant a temporary injunction. The temporary injunction only is during the, it operates only during the time interval between the filing of the case and the judgment. So, it is only to keep the property intact. So, there are so many such orders which are for only to see that the person is protected or the rights of the person is protected during the pendency of the trial. So, this is the object. Then what are the different interim orders under the Civil Procedure Code? Let us see. One is payment in court, that is order 24. Security of for cost is order 25. Then we come to 26, 38 and 39 and 40. So, we have different interim orders which we will be discussing one by one. Payment in court, that is order 24. The defendant can, in a suit for debt or damages, debt, DEBT, this is a mistake here, debt or damages, deposit in court at any stage of the suit such sum of money as he considers in satisfaction in full of the plaintiff's claim. Now, when there is a debt, a person files a case in order to recover the debt. That amount has to be paid, right? When that amount has to be paid, the person who has to pay the amount is the defendant. The plaintiff files a case against the defendant. Once the case is filed, the defendant may come on his own and deposit that amount in the court. Suppose he deposits that amount in the court, then the court will receive that money, give the notice of the deposit to the plaintiff as per rule 2, and the plaintiff has to apply to the court asking for the recovery of that amount, saying that he wants to receive that amount, and then the amount will be paid to the plaintiff. So, the amount of the deposit shall be paid to the plaintiff on his application unless the court otherwise directs. So, the notice of the deposit shall be given because the plaintiff should come to know that the amount is there, and the amount of the deposit, once it is paid to the plaintiff according to his application, then it means that the debt is paid. So, when the amount is paid according to this particular procedure, what is the meaning of or what is the object of this particular provision? See, the main object is that once you file a case before the court, you are going to incur costs. Yes. So, once you start incurring costs, the other party also incurs costs. Plaintiff incurs costs because it is his cause of action and it is his right. The defendant, if he is at fault, he is liable to incur costs. But suppose the person comes on his own as soon as the plaint is filed, the defendant comes on his own and pays the amount, then the costs are saved. So, the purpose of this provision, that is to give an interim order on costs, that is the purpose of this particular provision. Rule 3 says that no interest shall be allowed to the plaintiff on the sum deposited by the defendant. Once the defendant deposits the amount, the plaintiff is not entitled to any interest. If the defendant does not deposit the amount and that the case is decided in the end, then the interest will be allowed to the plaintiff. So, that interest is not allowed if the defendant deposits immediately, because it shows that he is prompt, he wants to give it, he wants to tender the amount. So, the intention of the defendant is clear in this particular provision. So, that is the purpose of this particular provision. Then rule 4 subclause 1 says, on the other hand, see, first of all it says, if the plaintiff accepts such sum as payment in full in satisfaction of his claim, then payment in full satisfaction of his claim, the court shall record his statement to that effect and pronounce the judgment accordingly, and in directing by whom the costs of each party are to be paid. See, the purpose is to save costs. So, if the plaintiff accepts that sum and in full satisfaction of the claim, the court shall record his statement that he has already accepted it, and of course, the plaintiff is required to give a receipt, and then the court shall record his statement that the full satisfaction has been given and shall pronounce the judgment according to that order which has been which will be passed. There the court will direct who has to pay the cost of that particular suit. On the other hand, if the plaintiff accepts the payment as satisfaction in part of his claim, suppose the plaintiff says that I am not accepting it as a full satisfaction, I am accepting it as a part satisfaction of my claim, then he can prosecute for the remaining balance. He is entitled to prosecute the suit for the remaining balance. Ultimately, when the case comes before the court, ultimately if they find that there is a actually that amount which was due to the plaintiff was the same amount which has been paid in the court, and it is not more than that, even though he prosecutes, he wants more money, right. So, he prosecutes for the balance. Finally, in the end the court comes to know that that is the only balance, that is the only amount which has to be paid to the plaintiff. In that case, the cost cannot be ordered to the plaintiff, because the plaintiff has just filed a suit without reason. He has got the money, he has got the amount as soon as he has deposited to the court. In such a condition, then the court will order that the plaintiff shall pay all the costs incurred by the defendant after such deposit, because of the plaintiff's prosecuting the suit for the remaining balance, the defendant is put to the cost of the suit. Therefore, the defendant cannot be put to cost when he has already paid the amount earlier as soon as the plaint has been filed. So, that is the meaning that the cost will not be ordered and the cost incurred will not be taken into consideration. That is the meaning of this particular provision. Let us give an illustration to this. A sues B to recover rupees 15,000. B deposits rupees 10,000 in full satisfaction of the plaintiff's claim. Now, the recovery of money is 15,000. B deposits rupees 10,000 in full satisfaction of the plaintiff's claim. Now, if A accepts the full amount as full satisfaction of his claim, though it is less than what he has asked, the court shall pronounce the judgment to that effect. But if A accepts that amount only in part satisfaction of his claim, he is allowed to prosecute the suit for the remaining 5,000 rupees. But finally, the court decides at the end of the suit, after the evidence is all over, the court decides that A is entitled only to rupees 10,000. Then what he will do is, he will have to pay to B, that is the plaintiff will have to pay to B all the costs incurred by B after depositing 10,000 to the court. When he has paid 10,000 earlier, he is not liable to be sued, but the plaintiff has prosecuted him further. So, whatever costs are incurred after that, then that has to be repaid or it has to be paid to B by A, that is the plaintiff. This is the illustration for this particular provision. Coming to some other illustrations, let us look into some other illustration. A owes B rupees 1,000, right. B sues A for the amount. B sues A for the amount, having made no demand for the payment and having no reason to believe that the delay caused by making a demand would place him at a disadvantage. Now, he has to pay 1,000, he does not make any demand to A at all, and he does not know whether he is going to put him at a disadvantage or whether he is going to not give him money or whether he is going to delay. Without having any reason to believe that there is a delay caused, he sues him. As soon as the plaint is filed, A pays the money to the court and B accepts it in full satisfaction of the claim. Here, the court should not allow him any cost, as the litigation is presumably groundless on his part, because there is no ground. If you would have asked him the money, he would have given him the money. If you would have demanded the money, without filing a suit also, he would have recovered the money. But he does not do so. So, he has filed an unnecessary suit before the court. He is not entitled to any cost from the defendant. Understand? So, he cannot ask the cost. Another scenario, after the plaint is filed. Now, when we spoke about the first illustration, what we said is A disputes the claim. In the first scenario, what happened? A comes and pays the money to the court. Okay. In the second scenario, he disputes the claim. He says that no, I am not due to pay him. Afterwards, he comes and pays the money to the court, which means that he knew very well earlier that there was a debt and he had to pay the money to the court. Then B accepts it in full satisfaction of his claim. What happens now? The scenario is different, because A, who was a defendant, knew very well that he has to pay the money, but he has disputed the claim, saying that I have not to pay. Later on, he realizes that he has to pay the money, and then he pays it, which shows his conduct. And the conduct, because of his conduct, it proves that the litigation was necessary by B. B has not filed an unnecessary suit. Therefore, court should give B his costs also, and A is liable for the costs also along with the amount. So, at the end of the suit, when passing the judgment, the cost will be awarded to the plaintiff in this case. You get the thing. Next, one more illustration. A owes B rupees 1000 and is willing to pay him that sum without suit. B claims rupees 1500 and sues A for that amount. Now, what happens? 1000 rupees debt is there. 1000 rupees he has to pay, but he claims 1500 and he sues him. When the plaint is filed, A pays rupees 1000 into the court and disputes only his liability to pay the remaining 500. He says, I have to pay only 1000, I am paying 1000. Now, B accepts 1000 in full satisfaction of his claim. If he accepts, then court should order him to pay A's costs also. You understand? So, because A, the defendant, has already said that I am paying only 1000, that is only the debt, and for the remaining 500 B has sued him. Ultimately, the court finds that he is only, because when he accepts in full satisfaction, a court comes to the decision that he did not owe him 1500, only 1000. So, that is why he is liable to pay A's costs also. So, this is how we are to look into these rules. Next, we can discuss about the next provision, that is order 25, that is security for costs. Rule 1, it says the court may at any stage of the suit order the plaintiff to give security for the payment of the costs of the defendant, and this power may be exercised by the court on an application by a defendant or suo motu by the court. This is order 25. Order 25 speaks about payment into court of the amount by the defendant. Order 25 says that if the plaintiff files any suit, the defendant has to incur costs. That is true. If at any stage the plaintiff leaves the country, or the plaintiff does not have any property with which the defendant can recover his costs. Suppose in the end of the case, the defendant wins the case, let us say, plaintiff's case is dismissed, then what happens? The defendant will be entitled for costs from the plaintiff. At such a, at such a situation, what happens? The plaintiff, if he does not have any property and the defendant is not able to recover, in the end defendant will be left with no relief, and that is why the defendant can apply to the court that the plaintiff should give security for the payment of my costs in case I win. So, that is the meaning of this rule. So, at any stage of the suit, even the court by itself, suo motu also, it can exercise this power, or on the application by the defendant also they can exercise this power. This is one thing where in these circumstances the court can make this order when the plaintiff resides outside India, or where there are two or more plaintiffs and all of them reside outside India, number 1. Second, where the sole plaintiff or none of the plaintiffs have sufficient immobile property within India other than the suit property. Suppose he does not have any immobile property in India, then even if the court awards cost in the end to the defendant, he cannot recover those costs because the property is not in India. Secondly, if the plaintiff is outside India, or where there are two or more plaintiffs, all are outside India and they do not have any property, that means if the defendant wins, he does not get anything, he does not get his costs also. If the plaintiff wins, yes, he will be getting his costs, because he will be getting his costs also and the claim which he makes also. So, plaintiff is secured, whereas the defendant is not secured. So, for that purpose, to restore the balance between the two, this is a very important provision, where the court will make an order in these circumstances. What the court would do is, see, this is the object, to provide for the protection of the defendants in certain cases where in the event of success they may have difficulty in realizing the cost from the plaintiff. Suppose there is if the defendant succeeds, then they have to realize the cost from the plaintiff, because they are put to unnecessary trouble by filing the suit against them. So, in this case, there is one case, Vinod Seth versus Devendra Bajaj, which has been cited in that has been decided in the year 2010, and Supreme Court cases, it has been reported. To provide for the protection of the defendants means normally the plaintiffs are protected because the court will order in their favor. If they win, they will get their relief. But the defendant who is brought to the court or who is dragged to the court without any reason by the plaintiff, if the court comes to know that he is having the claim is not being proved, or he is not able to prove his claim, then it dismisses the case of the plaintiff. And at that time, because the defendants are put to unnecessary costs, the cost of the suit is awarded to the defendants. So, for that purpose, to secure the repayment of the cost to the defendant, this order 25 comes to help. Now, the court asks him to furnish security. At the time when the plaint is filed, the defendant files an application or suo motu. The court says that you have to furnish the security. Suppose the plaintiff does not furnish the security within the time fixed or extended by the court. Sometimes the court can extend the time also. He may say that I am not able to give the security within this particular time, please give me more time. So, when that is requested, the court can extend the time also. We know that in courts, normally courts looked into justice. They do not become very technical about it. Suppose they have passed an order, the court passes an order, the most time will be given, the most justice will be given to the person. So, the defendant or the plaintiff, the court looks into both these as the balance of the right should be there. So, the court shall dismiss the suit if the security is not furnished, unless the plaintiff or plaintiffs are permitted to withdraw therefrom. What happens is, if the security is not furnished within that time, there is no other option, the court will dismiss the suit. Then, before dismissing of the suit, the plaintiff can be permitted to withdraw also. If the plaintiff withdraws the suit, then there is no suit and the defendant is free. So, that is, even before the suit commences, these steps are to be taken. When the suit is dismissed under this rule, later on the plaintiff may suffer because he is not able to file another suit on the same ground of action, right? The decree is passed. So, therefore, this plaintiff may apply for an order to set the dismissal aside. When he applies for an order to set the dismissal aside, and if it is proved to the satisfaction of the court that he was prevented by any sufficient cause from furnishing the security within the time allowed, then the court shall set aside the dismissal upon any terms as to security, cost, or otherwise as it thinks fit, and shall appoint a day for proceeding with the suit. That means the suit is restored. So, for example, suppose a plaintiff is asked to furnish a security. He says yes, he does not furnish security within that time. So, the court dismisses his suit. Later on, he files for setting the dismissal aside. After he files for setting the dismissal aside, the court looks into the matter, whether he has any sufficient cause, for what reason he was unable to furnish the security within that time. He has to satisfy the court that there was a reason, any reason could be there. For example, we have seen that by sufficient cause a person is not able to file his written statement in time. So, in the same way any sufficient cause may be there. For example, he may be sick, or he may be out of the country, or he may not have got any person for as a security, or he may have asked somebody to be a security for him. That person may have delayed due to some reasons. Any reason which is able to prove before the court that it is sufficient, not just avoiding it. So, by sufficient cause, if he is prevented from furnishing the security within that time, then the court will look into the matter and the court shall set aside the dismissal on any terms. For example, it may say that you give security for that, also you pay cost for the delay, or any other condition which it thinks fit. The court can give those terms, that is impose those terms, and the court can appoint a day for proceeding with the suit, and the dismissal is set aside and the suit is once again restored. So, this is a second interim order wherein security for costs can be asked before the court, or the court itself can award in order to protect the rights of the defendant to recover costs from the plaintiff in case he has in the ultimate that is end of the suit won the case, and he has won the case in the sense the plaintiff's suit is dismissed against the defendant. So, the defendant is able to recover costs. For those costs, the security would be asked to be furnished when the court comes to know that the person, that is the plaintiff, may not be able to pay those costs as he is outside India, or as he is not having any immovable property from which those costs could be recovered in the end by the defendant. So, that is the purpose of this provision. So, this dismissal shall not be set aside unless notice of such application has been served on the defendant. So, once he files an application to set aside the dismissal of the suit, the notice will be served on the defendant, because the suit is dismissed. The defendant does not know, he needs to know that it has been recovered, or he has filed an application. So, defendant could file an objection to that application if he wishes. So, the notice of that application has been served on the defendant, and the defendant appears before the court, and then the court will look into both of the plaintiff and defendant's say, and the court will decide the matter, and it will be restored, the case will be restored. So, we can see that these are the provisions wherein there is a balance maintained between the interests of a plaintiff and a defendant. Normally, interim orders are having the object of protecting the interests of both the plaintiff and the defendant in a suit. Any order in between can be filed when the suit is going on, if the court thinks that, or the court is satisfied that the interests of the plaintiff may suffer, or the interests of the defendant may suffer, the rights or claims of the plaintiff may suffer, or the rights of the defendant may be injured if certain steps are not taken. Therefore, to take those steps, a person can file, or a plaintiff or defendant can file a application for interim orders. So, these are two interim orders which we have discussed today in this case, and we will go to the remaining provisions, that is all the other interlocutory orders which are passed by the courts one by one we will be discussing in the forthcoming classes or the forthcoming sessions. Any question is there on these matters, or any doubt is there on these matters, or you have a particular case in which these matters are to be discussed, or the technicalities of this particular provision, because we are discussing the Civil Procedure Code, which is a very vast code and which was enacted in 1908. There are so many provisions which have to be interpreted by the courts, and it has been interpreted, of course. So, any doubt is there, please feel free to comment, feel free to provide me feedback, so that I will be able to be sharing my knowledge with you and my experience with you through these sessions. Thank you.